Welcome again to the Melling Law YouTube channel. Today we're going to talk a little bit about estate planning basics. Now, there are going to be about 3 courses we're going to cover today: Estate Planning 101, Estate Planning 102, and then Estate Planning 201. So we're going to get a little bit advanced, but pretty much stick to the basics here. So, contrary to popular belief, Estate Planning 101 isn't planning for death, but rather planning for incapacity. You never know if there's going to be an unexpected event that may leave you unable to make decisions for yourself. For these, it's better to have proxy decision makers or someone who can make a decision on your behalf. This includes situations where you're physically unable to communicate for a long term, or times when maybe there's a cognitive issue, such as dementia, Alzheimer's, things like that. Also, planning for short-term disability, like if you're in a car accident, in a short-term coma, things like that. And then sometimes it's nice to have someone in place for emergency financial account access, like say you're overseas and need some money wired to your account. Now, the instruments we use to put these proxy decision makers in place are called living wills and powers of attorney. We covered those in 2 other videos, which I've linked in the description below. But just to review, the first document we call Advanced Health Care Directive, or Living Will. That in that document, you nominate someone to make decisions on your behalf. You can talk about your organ donation preferences, your life-sustaining treatment option preferences. This document can even authorize your agent to make end-of-life decisions for you over wishes of other family members. So if you want to be taken off of life support under certain circumstances, and you don't think that the family members that the hospital would normally ask to make those decisions would take you off of life support in those circumstances, then if this document's in place, you can have someone else who's willing to make those tough decisions make those decisions for you. Another document on the financial side is the power of attorney, and that with that you choose someone who can represent your financial and business interests. Now, by law, at least in Utah, there are a lot of built-in restrictions and protections. I explained some of those in another video, but you'll really want to speak with with an attorney to see what your plans are. Some of these restrictions you can't even waive in the document, so they're there to stay. So you want to be sure what those are and how that's going to work. A big thing with this is if you make it durable, it remains effective after disability, which is when you really want it in place anyway, to avoid a court-ordered custodian or conservatorship, I should say. Another misconception with powers of attorney is that they are a lot of people think that they're effective after death, and that's simply not true. The power of attorney ceases at death, so after that point, only the personal representative of your estate or a trustee, if you've got a trust in place, can continue to make those transactions, but your power of attorney cannot. Now, estate planning 102 would be planning for death instead of incapacity. We used to say there are 2 inevitables of life, death and taxes. Well, a lot of us don't pay taxes anymore, so let's just say there's one inevitable in life, that's death. And since it's something that's going to happen for sure, it's probably worth planning for. Your property will be treated under one of 3 systems, and we're kind of going to go through those different systems and talk about the pros and cons of each system and the ways your property will be treated. Now, we have intestate property, which is property that's owned in your name. It's not otherwise governed by a contract or anything like that. And this is if you die without a will. So it In that case, property that's considered intestate property is passed according to probate laws. Now, testate property is the same property that's owned in your name, not otherwise governed by a contract or anything like that. But because you have a will in place, it goes to whoever you want it to, according to the terms of your will, and that's supervised by the probate court, by the probate process. Now there's contract property. May or may not be owned in your name. This could be a home that's owned as a joint tenant with right of survivorship. This could be trust property. This could be pay on death bank account. But its distribution is governed by contracts, so it passes outside of the scope of a probate process. Now, if you die without a will, if you have contract property in place, it's governed according to the terms of the contract. So your house goes to the other owner if it's owned jointly. Retirement accounts are usually handled, and they go to the beneficiaries. Same things, investments, insurance. These are all considered kind of contract property. However, everything else, this may be your home if it's owned by you only. A lot of people's bank accounts, especially personal property, vehicles, these will go according to the probate rules if you die without a will. Now, that may take 12 or more months for that process to take place. In small estates, there are ways around probate, but for most people, this is going to be a pretty long process, longer than people care to go through. Now, the general rules here, there are some variations, but everything will generally go to a spouse. If any of your kids are also children of that spouse. But if there is no spouse in place, it all goes to the descendants, and there are other ways that it might be distributed if there are no children or spouse. Now, if there's a spouse and then you have children from a previous relationship, the first $75,000 of the estate will go to the spouse, and then the remainder will be split two ways in equal halves, one half to the spouse, one half to the remaining children that are not children of that spouse. This gets really messy, and a lot of people don't like this arrangement, which is why it's ideal that people get some estate planning in place to make sure that this doesn't happen. Now, if there are no children or spouse, generally everything will go to the parents, and if no parents, then to siblings and their children. Now, dying with the will is a little bit different. We're still going to have contract property handled according to the terms of the contract, just like dying without a will. However, anything in the will that's mentioned and not otherwise governed by contract is distributed according to your terms. So we want to differentiate here, because sometimes people think, well, if I put it in my will, then that's what's going to happen, and that's not necessarily true. Like, let's say we have a retirement account. The retirement account lists your children as beneficiaries, but in your will you decide you want to give everything to your niece because she's trying to go through veterinary school. Well, that retirement account that lists your children as beneficiaries is what controls that trumps the will. So even though in your will you say everything goes to your niece, those things handled outside of the will are still handled according to those contracts. Another thing that we include usually with wills is a personal property memorandum. So rather than saying in the will itself, well, I want the Steinway to go to Alice and the KitchenAid to go to Bob, you'd probably be changing your will a little bit too often if you were giving out little things like that in your will. So what we say in your will is, look, any personal property will be handled according to a personal property memorandum. And then that's a little piece of paper you keep separate, and you can change that as you please. Just do a little signature by each item, and that way you can change personal property items later on down the road without having to formally change your will or write over it, which causes more problems than I want to even discuss in this video. Um, Now, there are some other possibilities in a will. You can even create what's called a testamentary trust, which is just a way of saying a trust created by a will. One of the things this can do is limit the distribution of inheritance for minor children. Um, Another thing you can do is in a will is nominate guardianship for your minor children. You can also nominate a conservator over their assets, so you can say, look, I want my one sister to manage my children's day-to-day activities and live with them, things like that. But I don't like the way she deals with money, so I'd rather have my other sister handle the financial affairs, and that's totally fine. You can do all that within a will. Some of the drawbacks of that are this lengthy probate process, especially with minor children. Even though there's an allowance they can take out of the estate, it creates quite a few problems. So there are other ways to deal with that. Um, but everything else that isn't mentioned in the will is distributed according to the probate rules discussed previously. Many people will put a residuary clause in their will to prevent this. So saying, look, anything I may have missed, I want to go to such and such person or divided among my children equally or something like that to just take care of anything that's left over, so it's not distributed according to the probate rules in the Utah Code. Now, we're going to get a little more complicated in here and talk about living trusts. So we're going to graduate from estate planning 101 and 102. We're going clear into the 200 levels with 201. Now, a trust is simply a form of property ownership wherein the grantor or donor or settler, there's a lot of terms used, but basically where someone is giving property to a trustee or a custodian, or however you want to put it, for the benefit of a third party. The living trust is where the grantor, trustee, and beneficiary are all the same person. You say, look, I want to set up an entity where I am giving property, I manage the property, and I retain a benefit in that property, but I want my death to trigger a succession plan where a new trustee assumes control and controls that property and distributes it for the benefit of different beneficiaries. That way it goes around the probate process and it can all be handled according to the trustee's timeline instead of the court's timeline. One of the biggest drawbacks of this plan is that all your property that you want in the trust must be retitled in the trust's name before your death. Otherwise, it has to be handled through probate. So dying with a living trust in place changes the structure a little bit. Once again, contract property is handled according to the terms of the contract. So, if you've got a jointly owned home, that goes to the joint owner that have the survivorship rights. Your retirement accounts, investments, and insurance goes to beneficiaries. Now, you can list your trust as a beneficiary. There might be some tax planning you want to do if that's the case, but in general, you can list whoever you want as a beneficiary. Now, the trust property is distributed according to the terms of the trust, and instead of being dealt with through the probate process. But everything, if you've got a residual will and it's not part of the trust property, it's still governed by the will. So, things that you might want to handle through the will are still, the nomination of guardianship for minor children, There are wills that are designed to be used with trusts called pour over wills, just to catch anything that might have been left over that you might have forgotten to retitle into your trust. And all it says is, look, I want anything that's left in my state that isn't part of this trust to be transferred over. So what this does is it gets rid of these probate and testacy rules, and it distributes the property according to your wishes. Now, there are some pros and cons of living trusts. The pros, a big seller is avoiding probate costs. Now, probate costs aren't like they used to be. Back in the 70s, Utah revamped their probate code to streamline it a little bit. We have small estate affidavits, which can help circumvent some of the probate provisions for very small estates under about $100,000. But there are still costs associated with probate. Another pro with a living trust is that it doesn't cost hardly anything to manage it. It's treated as you for tax purposes, so any trust property is just treated as your property on your personal income tax return while you're alive. And then another thing that people sometimes gloss over is that out-of-state property can also be kept out of probate in that state. Depending on that state's rules, you're never 100% sure, but you'll want to talk to an attorney about these options, especially if you own property out of the state of Utah. But generally, if you have a living trust and you've retitled out-of-state property in that trust, that way you keep it out of probate in that state as well, so your kids aren't paying probate in two states. Now, a con of living trust, several cons. One is that you're avoiding probate, which means you're also avoiding the safeguards and oversight of probate. It's overseen by the court, so you're losing some of that protection. There's an upfront cost associated with living trusts. They can range anywhere from $500 to $1,500 or even more, depending on your family planning and your goals in having the living trust. And there is a potential for transfer taxation. It really just depends on your property. Like I said, this is something you'll want to discuss with your attorney. Another con is that all property needs to be retitled in the trust's name. So if you forget to retitle it, then it's not part of the trust. And then another part is there's a lack of creditor protection. So living trusts have no asset protection capabilities. There are you can do asset protection trusts. Utah has a special code provision for it. Those are generally much more expensive. We're talking about capital gains at that point as well. There has to be special trustee issues. So that, living trusts, we're talking about estate planning 201, asset protection, that might be in the 300s category, right? We're a little more advanced there. If that's something that you'd like more information on, feel free to talk to an estate planning attorney. But a living trust offers none of those asset protection qualities. So to kind of go over what we've covered today, this chart, you feel free to screen cap it or however you want to do it, or request a printout. But these are kind of some of the qualities of different instruments. We've got our living will / advanced directive. We got our power of attorney, our last will of and testament, and a living trust. They all have different properties, but as you can see, not every instrument has all these qualities. So that's why a comprehensive estate plan encompasses 2, 3, or maybe all 4 of these documents. So finally, why should you plan your estate? There are several benefits to planning. The biggest one is that it's much less stress on your family if something happens to you, whether it's an accident or whether you die of a long-term illness. Sometimes death is expected, sometimes it isn't. and your family has a much easier time managing your financial affairs if they're in order, and then they don't have to worry about the finances as much, and they can focus on grieving your loss and moving on. Now, another benefit is that your family has access to these accounts and the funds without having to go through the probate personal representative or anything like that. It eases the grieving process, and then there's a potential for great cost savings in probate, especially um, anything like a will contest we have these huge. There can be a huge expense associated with litigating a dispute in probate, and a properly planned estate tries to avoid future contests, and there are different tools you can use to do that. But a big part of it is just having the estate planner understand your family dynamic and what the picture is going to look like when you've passed on and how family might react. And so a big part of what we do as estate planners is work with you to figure out what's going to happen in your family and how can we make sure that their costs are kept low and that there's no incentive to litigate the estate. And then I'd like to just close by letting you know the first thing you need to do if you're married is discuss your values with your spouse. You need to decide, okay, what do we want to happen to our children or grandchildren? What are the terms under which we'd like them to receive an inheritance, if any? Do we want them to finish a degree before they get anything? Do we want to care for their basic needs? And in the meantime, these are things you want to discuss. And when you have a little bit of a picture of what you would like to happen if something were to happen to you, schedule a consultation with an estate planning attorney in your area, and you can find out what steps you need to take further, whether you need to just have a couple of basic instruments in place or whether you need to do some more advanced planning. You can reach us at Melling Law anytime at 435-572-0807 or via email at office@mellinglaw.com. We do free consultations, and we're happy to discuss anytime with people when they want to learn how to plan their estate. Thank you for joining us. Please subscribe for more updates, and if you have any suggestions on presentations you'd like to see in the future, please let us know in the comments below or email us directly. Thank you.